Welcome. This is Tommy Ruke with the Transportation Risk Specialty Truck Stop webinar. These truck stops are presented the second Thursday of each month at 2 p.m. Eastern Standard Time. These webinars are presented as industry updates for informational purposes only and do not qualify for state CE credit. We do have webinars that do qualify for state CE credit, and if you are interested in state CE credit, please contact Beth in our office, and we will arrange to have those for you. If you have questions, please place them in the chat window. They'll be answered as time allows or respond later after the webinar is over by email. We'll share the answers and questions with everybody who attended the webinar. If you experience any auto problems, please send us a note in the chat window or call our office at 800-741-4084. We'll attempt to correct the problems as soon as possible. As our friend Rob Mosley says, the motor carrier lives in a glass house. What did that statement mean? As the insurance units are going down the highway, if their behavior gets the attention of an enforcement officer, they get stopped for an inspection. The results of these inspections are then available to the public. We have had presentations on the inspection results that show violations of FMCSA's rules. The insurance industry looks at the violations and the scores as part of underwriting and pricing the risk. These violation scores become a consideration in the motor carrier's ability to obtain insurance. Until a year ago, before the FAST Act, the CSA scores and alerts were public and used by shippers as well as insurance providers as part of their underwriting. Congress required the FMCA to take down the scores from the public website. So the information was no longer available on the free public site, but it's still available through third-party providers. The third-party providers pays the FMCSA for access to the results and then writes programs that approximate the FMCA scores. Are these scores and alerts accurate? Close. Not exact, but close. The reason that they might not be exactly is because of two factors. The first factor has to do with the time the reports are run. If there was an activity between the time the third party runs theirs and the FMCSA runs theirs, any change in those activities, then obviously the scores will be changed. But most of the third parties are running these scores at the same day, at least. The FMCA is running theirs. So those scores, tests show 99% accuracy reflect the exact scores. Of course, we do not know the exact scores unless we have the motor carrier's PIN number. But the reason I point this out, every now and then you will go to an insured or could go to an insured and say you have an alert, and the insured might disagree with that or the scores because it might be a point or two off percentage-wise, and this is the reason why. The second is the FMCA scores are based on inspections done on the road. This is the inspections that we see, not at the motor carrier's location. The DOT enforcement officer could visit an insurer's location as part of the CSA intervention process. They could be an unrated focus where they're looking at one area like maintenance or hours of service, or they can do a full compliance that would lead to a rating. As you know, the rating could be satisfactory, conditional, or unsatisfactory. If the on-site visit could lead to finding of acute or critical violations discovered, a finding like this placed an alert that stays with insured for a year, even if the cause of the violation has been resolved. So this is an area where there might be an alert that is not because of the roadside activities, but because of the on-site inspections. Currently, I don't know of a third-party provider reflecting these alerts, and I really don't know how they could without the insured's individual PIN number. They do reflect the investigations and the results of the investigation. So when we get the reports from the third-party provider, or even if we go into safer and our own view, you can see where they had these inspections and why, on-site visits and interventions and why, and you know that there would be an alert then established there. that will stay with the insured for a year. I was pointing out these items because of what we're using the information for now. But let's talk about something else. Let's look at the operationals of the insured. The units the motor carrier operates. As most of you here on this program understand, the basic insurance rule, the insurance provider wants to know about all units, owned, leased, borrowed. The motor carrier operates under its operating rights. This is necessary because, obviously, MCIEF 90 protects the public from all units the insured operates under the DOT number, 10,000 GVW or larger, so we need to account for it, underwrite it, and price for it. The policies for a smaller motor carrier, one with less than 20 power units, typically requires these units to be listed on the policy for them to be considered a covered auto. So we have that concern. I realize that in some cases we have coverage that's provided in hired car. We're not getting there, but most of the insurance providers want those units to be listed on the policy, again, so that we can underwrite it properly. We know operating those units, and we get our payment for it. Often the insurance carrier finds out about a unit being operated by the insured, but not on the application submitted or on the policy if it's already been issued. They track the numbers through these. When this happens, the insurance provider goes back to the agent, wholesaler, and asks about the units. If they don't receive a satisfactory answer, the insurance provider takes action. We'll talk about that action here during this program. So we're asking, where does the insurance provider get the information? The questions are based on information provided by the insurance company underwriter to the insurance company underwriter by the third party from the information they obtain from the inspection reports. Before the risk is written, they ask a request to find out what vehicles have been inspected in the last, and it depends on insurance carriers, 6 months, a year, of the full 2-year cycle. And if there's some that have been inspected but not on the policy, we get the question, where are those units, or what happened to those units after the policy is issued? Then they track those items there. Some of the carriers track the items through the last 24 months inspection. Some give a list based on the ones that are that are listed on the policy. So the third-party provider that the motor carrier the motor carrier uses is a member of, most carriers, insurance carriers use as a member of the foundation is Central Analysis Bureau. They are the provider of most of the programs that most insurance companies are aware of, use that system, and it's been a very useful tool for underwriting and pricing and screening of a risk. Carrier Software is also a member of the foundation. It provides third-party providers to some motor carriers as well as some retail agents who try to track these scores on a daily basis, which can include tracking any vehicle being inspected that's not on the current policy. So these are the two systems that the insurance industry are using that have paid the fees to the FMCSA to access this inspection information that then gives these reports back to the insurance provider or to the retail agent, whoever has subscribed or have bought their services. To better understand the information on the inspection reports, I asked our friend and transportation expert, Bridgette M of the Taylor and Association, to ask Captain Gay if he would spend time with us to explain the information that's contained in the inspection reports. I've also asked John Love with W. Love and Associates to be a part of this session with his questions about the meaning of the information and the answer he receives from the retail agents, being the intermediary. As you know, John deals with this for a long time. So we're going to try to walk through some of these questions and answers and try to drill down to exactly what information we see and how to interpret that properly. Welcome, Bridgette. Welcome, Captain Gay. Welcome, John. We have their bios on the line here, and we appreciate the time they're spending with us today to put this program together.
Thanks, Tom.
Bridgette and Captain Gay, John, I have put together a few questions. We will move forward. Bridgette, are you there?
I'm here. Good morning.
Captain Gay, you with us?
Yes, sir, Tommy. I'm here.
John, you have already said you're with us and all that, and so let's go forward. The first question we had, Captain Gay, is the motor carrier stopped and inspect starts. We see on our reports truck, tractor, trailer, and then we understand that the DOT is 10,000 GVW or larger, which would be a dually pickup, but we've seen some with a pickup and a trailer. Just as a very overview, can you discuss your approach to stopping these various units and how you describe those so we can get understanding how to interpret when we see those?
Out here in the field, there's probably two different ways we will make a inspection stop. One, either mobile enforcement, where we stop you on the shoulder of the road, and two, we either select you to come back to the inspection barn at our fixed scale facilities in the state. And two reasons why we would select the vehicle is either we observe some type of violation, like a vehicle defect violation or a traffic violation, or we could just randomly select the vehicle to do a roadside inspection. So anything that appears to be a commercial motor vehicle, like you mentioned, if it has a gross vehicle weight rating or gross combination weight rating of 10,001 pounds or more, we could select you either on the roadside or in a scale facility if we see a violation, or we just randomly select you to do the inspection.
I assume a truck is one where the carrier compartment is attached to the power unit versus a tractor and trailer that we're familiar with.
I'm sorry, ask that question again.
You have a truck. That's where the carrier compartment is attached to the power unit. Those are where we have the box trucks, and those are the trucks, right? Then the tractor and trailers are the other areas. Is this how they divide up when we look at it?
Yes. What we identify as a straight truck is where the truck itself has a cargo carrying capacity, and then a truck tractor is something that's usually only designed with some kind of coupling device like a fifth wheel on a frame, and then which is only way it can transport a load is pulling the trailer.
And then we had the 10,000 GVW. Do you stop and often inspect a unit 10,000 GVW, just a dually? What would incentivize you? Clearly, they're not the obvious ones you see on the highway, the big tractor trailers. What would incentivize you, or have a reason that you would stop one that's a dually? And also, we see some of these that don't even go through the weigh stations or the inspection stations. Are those some that are on your radar screen, or they kind of flow below it, or what would make you interested in, or interested to look at those?
Well, like those small trucks you're referencing, the dualies pulling a small trailer. If they go by the scale facility, that is going to be like a sign for us to go stop them, because obviously they're not complying with the regulations if they don't know to come into the scales. So typically we usually go and catch them bypassing scales, bring them back, and do the inspection. And when we see these trucks, because your everyday average person doesn't drive around in a heavy-duty type dually truck pulling a utility trailer just to drive around town. So usually there's some type of commerce associated with vehicles that appear to be bigger than your everyday vehicle you travel in to and from the grocery store. So if we see one, there's no identification on it, there's not any USDOT numbers displayed, or if the vehicle passes a scale, then we'll probably make contact with that vehicle and verify if they're authorized as a for-hire motor carrier or a commercial vehicle.
Would there be a reason?
Hey, Tommy, may I ask a question? Y'all, I think this is very interesting because, Captain Gay, this goes to one of the investigative things that we have to go through when we're looking at the VINs that have been inspected under a certain DOT number, and do a VIN validation and find that, at least through VIN validation, that the vehicle that has been stopped weighs less than 10,000 pounds. So my question is twofold. One, would you have a way to know, or would you purposefully stop a vehicle that weighs 10,000 pounds, less than 10,000 pounds? and or one of the assumptions we've made is that there must have been a trailer attached to that truck.
And that's correct, because the definition of commercial vehicle is gross vehicle weight rating. That's the single unit, what it weighs at the time of the stop or what it's rated to weigh, and gross vehicle or gross combination weight and gross combination weight rating. So if a truck, a dually, say about 9,000 pounds GVWR, is pulling a trailer about 20,000 pounds, we add the two together. And if that combination, if that combination exceeds 10,001 pounds, then it's a commercial motor vehicle.
All right, so I'm just going to follow up with a brief question or point, Tommy, and I want Captain Gay to answer.
No, please.
Okay. If you were to get, if someone were to tell me, hey, well, that vehicle was inspected, but it weighed less than 10,000 pounds, would you think that answer is suspect because we don't know what the trailer weighed, and you most likely would not have inspected that vehicle if it did weigh less than 10,000 pounds? And
that's correct. And on our inspection reports, we indicate the weight ratings for both the truck and the trailer. So if you can access their inspection reports you should be able to see that the reason why we identified that vehicle as a commercial motor vehicle. And a lot of times we put it in our remarks section because if it's a commercial vehicle but they're not operating in compliance as a commercial vehicle, there's going to be a lot of penalties and citations associated with it.
I just want to clear one thing up. When we talk about GVW, we're not talking about the weight of the unit. We're talking about the carrying capacity of the unit, which would include the weight of the unit plus the cargo and load. I realize we talk about the weight of the unit in our discussion here. And what I talk to most of the people, Officer or Captain Gay, is that a dually would be one with 6 tires. A pickup truck would be one with 4 tires typically. And that 4 tires plus the trailers then would equal the 10,001 GVW. Captain, that's how I define it. But that's no big deal. I mean, I know how the language we use, and often we hear it spoke that way. I just want to make sure that I understand that correctly.
Yes, and to define a commercial vehicle, we use both weight rating and our actual weight. So if a vehicle is rated for, say, 9,900 pounds, but they're loaded and weighing 12,000, will also put them in a commercial vehicle category because we go by both. If you look at the 390.5 definition of commercial vehicle in the regulations, it includes both the rating of the vehicles or the actual weight at the time of the stop of the vehicles.
Right, that second was what I was clearing up. When we're talking about the weight of the unit, we're talking about the actual weight of the unit loaded and being operated. That was the point I was trying to make versus just the weight of it empty. That was where I was trying to bring that difference up. Okay,
yes.
John, let's go to something else here. What do you use to report the name of the motor carrier on your report? We say typically it's a name and DOT number on the side of the unit. Do you use any other method of that, or is it just that simple? Whoever's DOT name is on the DOT numbers inside the unit is the motor carrier that you put on the report.
No, we don't. That's where we start with the actual name and DOT number displayed. But we also try to verify with what's the log books, the bill of lading, any supporting documents, and also we even interview the driver to verify who is the correct operating motor carrier, because we know that's so critical to identify the motor carrier because it plays a critical part in everyone's safety rating. So we typically go beyond just looking at the side of the vehicle, and we try to verify that everyone we're issuing a roadside inspection to is the correct motor carrier.
Well, that is a real critical thing to us because we get a lot of conflicting stories back about why an inspection appeared in this specific DOT number, and the answer we get back often was, well, it was my DOT number on the side of the truck. I agree with that, but the bill of lading was a different DOT number and the inspection is not correctly reflected. Could that happen, or is it standard procedure? I mean that causes issues here.
Yes, John. I mean,
actually had that a little later here, and about the bill of lading and all that. And let's hold that till we get that slide. So I hear we're saying we start with the name on the side of the truck, and that's the DOT number. That's where you start. But there's further investigation later by, as you say, whose name's on the logbooks. We'll talk about the bill of lading, if it's a lease arrangement or some other things that go beyond that. And then we'll talk about how you note those things. And so that's where we start, but that's not where you're finished. That's what you're telling us, Captain, correct?
That's correct.
Okay. So if the unit is not owned by the motor carrier, whose name's on the side of the unit being inspected, what do you do to verify the owner-operator has the right to use that DOT number? And this gets back to that verification, and we'll talk, John, in a second about the bill of lading. But lease arrangements, is there a lease? Is there a verbal lease? We hear it's a permanent lease, a trip lease. We hear they got no insurance. So now we're talking about where you stop the truck, the DOT number, but you also look at who owns that truck, and there's a difference there. How do you handle that situation? And then not only if then the inspection, what motor carrier is going to reflect on the inspection, but what do you do if this is not properly documented or handled?
If we come in contact with a vehicle that's not owned by the operating motor carrier, once again, like the previous questions, we will look at everything, the logbook, the bill of lading, and then we will ask the driver for a lease agreement. If the owner of the vehicle is not the motor carrier, then we're going to try to get a lease agreement. Now, unfortunately, Part 376 requires them to have some type of documentation on the vehicle identifying a lease agreement, but there's not like a severe enforcement action we can take on the roadside. So if they don't have it, it's not like we could place them out of service or anything. So we will try to get a lease agreement to verify who's the operating motor carrier, and if that vehicle has permission to use that authority, and even if we can't get anything to verify it, we will call the motor carrier. So if an owner of a vehicle or a vehicle has a motor carrier's name displayed, and there's nothing that satisfies us on the roadside that driver has or that vehicle has a lease agreement, then we'll call the motor carrier and verify, giving them a driver's name and the vehicle VIN, and typically we get an answer fairly reasonable time. So yes, we do try to verify the lease, and can there be a verbal lease? There's nothing in Part 376 that permits a verbal lease. So what we do is, like I just mentioned, we try to verify through a document that the driver should have in possession on the vehicle, and if we can't get that, then we will go further in contacting the motor carrier.
But on the inspection report, who's the motor carrier?
Whoever is going to be the operating the vehicle at the time. So who's responsible for the load, and who is the vehicle under dispatch, who's dispatching the vehicle. So that's what we got to find out, because because of the owner of a vehicle is different, we typically don't list the owner as a motor carrier. We're going to determine if that owner has the permission and it has a lease agreement, and so whoever we identify as the motor carrier will be the person or the company that we identify on the roadside inspection.
So it would typically never be the owner of the unit unless there's other documentation that they are the operating entity.
Yes, if we find out that the driver either does not have a lease, or he's using someone else's authority without their permission, then that owner will be identified as the motor carrier, and he or she will be cited for operating without authority, and all the penalties and the violations that go along with that.
Hey, Captain Gay, in your opinion, in instances like this, are drivers, the drivers that are being inspected, the individual who you're talking to, are they usually able to answer these questions directly and without hesitation, or do you think that a lot of times the drivers are either confused on one hand or maybe trying to hide something even on the other hand?
But the ones that are doing it legitimately, where they have a legitimate lease and everything what it should be, those usually are quick to answer the questions and provide you with a copy of the lease. It's the ones that typically are doing something wrong or illegal is the ones that, you know, have a hard time answering questions or conflicting statements from when we contact the motor carrier.
Well, may I follow up and say, in your opinion, what are the things that you think are being done illegally or being hidden most often that you've uncovered through your experience?
Well, we find a lot, especially these new entrant carriers, where somebody got 2 or 3 trucks and they recently registered and recently received operating authority. Well, especially South Florida area, they allowed their uncle or brother or cousin to use their authority for 1 or 2 trips, and then whenever that person they allowed to use it, once he realized, hey, I can scam and get the full amount of this load, and that person would kind of go off road, or he'd go off and use their authority and without the permission. The problem we're seeing is these new entrant carriers with just a couple of trucks, they're allowing friends or relatives to use their authority, and then find out later that friend and or relative using it continue to use it down the road or later and without their permission.
So if I understand you correctly, let me just ask this time, I want to understand. The carrier where the inspection might show initially had knowledge that that individual was operating, but then later did not. You're seeing one lead to the other, a permissive use to start with, and then someone saying, well, like, I can abuse this and I don't have to, I've got a way to get through an inspection without having my own insurance.
Yes, and that's correct. A lot of times, like, are you familiar with data queue challenges?
Yes, sir.
Yes, Bridgette gave us a study with that. Bridgette, that's your sweet spot. Thank you for mentioning her, especially.
So most of our data queue challenges we get from the industry reference, you know, we misidentified the motor carrier. Most of ones we get, the person who's using their authority was given permission in the past to use it. They just they abuse it, and they continue to use it without the motor carrier's permission. So I feel like, because I've seen it and see how easily it could happen, when these guys use someone's authority, they're given permission. Well, later they realize, hey, I can find my own loads and make the full amount of money off of it without having to pay insurance. So they continue using someone's authority without the motor carrier's permission, and they're out there operating with their name displayed and their insurance information in their vehicle and stuff like that. So it's like they take advantage of it, and they abuse using someone's authority to make more money off the load and not have their own insurance or not have their own authority.
So what we're saying here is that when you stop the load, we start with the name on the side of the truck. If it's not owned by the person named on the side of the truck, there should be a lease. There should be a copy of that lease in that vehicle, but often it's not. And if it's not, then you do further investigation to determine if that unit has the right to use the name on the side of the truck's rights to operate. Is that not what we're concluding with this discussion? Yes,
sir. That's exactly right. And
okay.
And we make a best effort to try to make sure we identify the correct motor carrier. We get, here in the Jacksonville district, we probably average only about one a month or one every 2 months of where a carrier is data queue challenging a roadside inspection because the vehicle that we inspected was not actually operating under their authority at the time. So we do a pretty good job in making sure we identify the motor carrier.
John,
and
you get this.
If I can just kind of build on what you're saying here, because we get those challenges where we get a violation and it shows up on our profile and we don't recognize that this is our truck, or maybe it was a truck that we terminated their independent contractor agreement, but they don't, when they're going through that inspection, they haven't removed the decals, they haven't removed the DOT number, they're still holding that lease. So from our perspective here, contractually, of course, we terminated the ICA, and contractually we require them to remove all the decals and the identification signage that would be on the truck. So I don't know if you can share any insight, but if that information is shown, let's say a motor carrier goes through, and you mentioned the data queues, which for the audience is a web-based dispute resolution procedure that allows individuals to challenge data that's maintained by the FMCSA. So in this particular situation, if we upload, here's a copy of the ICA that we terminated, or here's the letter that we sent to the driver terminating their operating authority, and that requires them to take down all the signage. Do you see that and accept that as a sufficient evidence to show that violation should not be tagged to the DOT number that was listed in the inspection?
Yes, ma'am. And what we'll do is revise the inspection, put the owner's name on the inspection, and re-upload the inspection. So yes, if you provide documentation that the purse or the vehicle was the lease was terminated, and we will reverse the inspection and apply it to the owner of the vehicle.
Bridgette, what you just went through, we also need to note from a technical standpoint, the old theory placard law, where if the name was on the side, you're liable for it, got changed many years ago, and what you just went through, there has also been some legal ramifications. You can speak to this, where that motor carrier is not going to be liable for operating that unit if they can prove that those leases were canceled and that that unit was no longer leased to them, and they were just abusing that use of that name. Am I correct also that those are court cases that you can handle, not going back through the federal filings or MCS 90 or the responsibility of the motor carrier if they can prove those things in court?
Right. So under the truth in leasing regulations, which Captain Gay was referencing under 376.12, when you do lease out your operating authority, the lease has to identify the authorized motor carrier and the owner of the equipment. Of course, that lease, the duration has to be specific, the date and time for which it begins and ends. And then also, among other things, of course, is that receipts are required under 376.11b, which basically says, here's the equipment, I'm identifying and maybe one or more equipment that is going to be operating under this authority. And if you terminate the contract with the independent contractor, then at the end of that lease agreement, you want to have a return receipt saying this equipment's been basically returned to the owner or is no longer operating under the operating authority of that given motor carrier. Unfortunately, circumstances don't always allow for the motor carrier to get that executed receipt if the driver may not, doesn't cooperate. So we have to take steps to show on our side that the contract's been terminated, that contractually, and this will be in the body of the contract, that here's what we contractually require the driver to do when we terminate the ICA. We give written notice, we send that out to the driver, make sure he's been served with notice of the ICA that it's been terminated, so that we can establish a record that we revoked that authority for the driver to run under our operating authority.
In those cases, we can get out of being responsible under the federal filings and our policies in that area, is what we're saying. Yeah, I have talked about that, exactly that. John, do you have any questions about that part of it?
No, I think it's very interesting, Tommy, and I appreciate what y'all have both spoken to, because what I'm hearing you say is that you don't have any control over doing what should be done when a lease is terminated. If when you stop a vehicle, the paperwork and what is presented to you appears to be in order, then you proceed. The fact that we've got vehicles on the road representing that they are under lease to a specific carrier when they are not is a problem that the trucking industry faces, which probably does give us inspections that should be challenged, obviously, by the DOT number where the inspection goes if they come to find that a vehicle that used to be under lease is still being inspected when, in fact, the lease has been terminated. Is what I've said in agreement with the way y'all would look at the situation currently?
Yes.
That's the way I understand it, yes, John.
Okay, all right, okay. So it is a
Now,
problem. We see this as a problem.
Right. Well, again, but I'm pointing out here, we have been successful defending the court cases away from the placard law that we can get out of responsibility. But the point that I think we're also here, if the insured finds out about this happening, then they need to take proactive steps in the data queue to get that removed so that they can correct that record. If they don't do that, then I think, again, they're maybe buying more liability. So that's something we might want to look at in that area to make sure they do have those procedures that Bridgette talks about and that I've included in previous presentations where they need to send a receipt. I've noticed your lease has been canceled. You no longer have the right to operate. Please return all the paraphernalia we've given you, our placard, our log books or whatever we have given you, T-shirts and belt buckles, because you don't operate anymore for us. And then if that happens, then lawyers like Bridgette and John, Jay and Rob and all can fight that in court cases and get us out of the liability. Bridgette, am I not? Is that kind of paraphrasing what we're saying?
Yes. The key is being proactive and taking the steps that we've just talked about here, getting the notification of the cancellation of the ICA, going in and filing that challenge in the FMCSA's data queues portal, all very critical to that step.
John, you get the memo back from the insurance provider that says that about these units not operating, and then you ask the agent to find out why the units was inspected under the motor carrier's DOT number and not on the policy. Unfortunately, the answer most often correct, as we just went through here, we hear is, I don't want to pay the premium. John, what are the answers that you're hearing, though, that's said back when you have that inquiry? And then I appreciate the officer's reactions to those.
I think by far the most common answer received is, we have absolutely no idea why that VIN would have been inspected under our DOT number. The second one that we hear as a distant second is, well, that guy used to be leased with me, but that lease is terminated, and y'all kind of covered that. And then the third one is that the GVWR is under 10,000 pounds. By the way, Tommy, a lot of insurance carriers now buy this data from the FMCSA, just as do these third-party vendors that you mentioned, Carrier Software and CAB. And so they're running their own internal computer programs that are verifying inspection VINs versus insured VINs. And I think we can all understand that that's where the rub is coming, in that Captain Gay, when you inspect a unit that the VIN comes back as not insured on the policy, that's where all the insurance questions come from, and they're very similar to the enforcement questions. It's like, well, why would this vehicle have been operating if we had not insured it? Do we have exposure here under our insurance policy? Who's protecting the public? What kind of farce is is there a farce, or is there just a mistake? I think that the insured and the retail agent and the general agent public probably says way too often the data is wrong. And I'm suspect of that answer, especially based upon the more I learn, the more I feel comfortable about the way data gets to a DOT number. But one question I did want to ask that relates to what Bridgette and Captain Gay do. If you stop that vehicle, the old-fashioned in the 20th century, the insurance ID card that's in the vehicle. It's required to be in the vehicle.
I have that in a second, John, about
I know you do,
insurance.
but the conflict between those, and we hear often, we wonder about the conflict between the what the driver presents as his insurance and what the DOT documentation shows. Just for when you get to it, Tom.
Okay. Well, we'll talk. But in this case here, but let me go back to what Bridgette just said and what Captain Gay just said. If they come back, John, and said that lease, we cancel the lease, it's not going there, don't you think it's appropriate for the insurance industry, you, the company, the retail agents say, give me proof of that cancellation of that lease? I mean, based on what Bridgette said, that should be...
We require it, yes. In other words, okay. we say, if that's the case, show me that lease was terminated.
Right, and properly done, like Bridgette said, and then there could be some less liability because they do it properly here. This also gets back important, John, that you and our soapbox is that important for the agents to track these vehicles that are being inspected through the CAB or carrier software that can track these units, and if one gets inspected, it's not only policy to ask the insured early on about it before it becomes a problem. That's another subject for another day, but I think that's important to do this. And done right, that's a legitimate answer, but so often it's not done right as we find out. Are there any other questions about the verification of the vehicles? We already went through the trip lease, the lease to known. I'm going in a minute about the bill of lading stuff and the proof of insurance. That's on the next slides or two. Any questions about that, John, you want to add to where we are with this?
Well, no, other than just to ask rhetorically, I mean, Captain Gay, you feel that the folks that you work with, and if I heard you earlier, you think that very rarely there's a challenge to the accuracy of how the data is being posted to DOT numbers, correct?
I can't speak on behalf of the entire state or nationwide, but here in Jacksonville, we average only about one a month, maybe, of where motor carriers challenging a roadside inspection because we misidentified the motor carrier on the inspection. So looking at that, it seems like between the motor carrier ensuring that who they have leased to them is being, if they terminate the lease, they collect all the credentials back, between their effort and our effort on the roadside to go beyond just looking at the side of the vehicle and verifying the motor carrier. I feel we do a fairly good job on making sure we identify the motor carrier correctly.
Yeah, and Tommy, although Captain Gay can't speak for everybody inspecting vehicles all over the United States, what you do and how you do is specified by specific written regulation and procedure, right? In other words, if you were operating as an enforcement officer in Oregon, you should be doing the same thing, right, that you're doing in Jacksonville. Is that correct?
Yes, that's correct. We the same training we do as far as inspecting vehicles here in Florida is the same training they do nationwide, including U.S. territories, Mexico, and Canada. So basically, what we do here should be the same thing they're doing elsewhere.
Bridgette, because you do this a lot for motor carriers, you get the data queue and orchestrate that. As you know, we've got a webinar that will available for that. We'll talk about that later. But how often do you see these challenges, and how often do you see the documentation is proper?
Well, I mean, it really is I would say, part of our practice on a week-to-week basis, and we just need to understand the jurisdiction for which the violation was issued and look at the what the process is in each state, because under the state analyst guide, which was put out by the FMCSA in December of 2014, each state can set up its own process for handling the data queue violations. So, for example, Arizona has its own review board. Minnesota also has something similar. And Captain Gay can speak to the Florida's three-tier process of review. So in these violations, when we get them, we have to look at first, where's the jurisdiction, so procedurally we can understand if the information is available to us, what the next step is in the challenge, and then looking at, okay, what information, like you said, what evidence, what documents do we have to support that the violation was incorrectly assessed, or was it a correct assessment, and it's a situation where we need to go in and address internally any deficiencies in our operations. So, we work, closely with our motor carrier clients and our drivers to make sure that they're retaining the right documentation. And also that one thing I wanted to add is that they also have their own internal auditing process set up so that they can look on their profile and see what inspections have occurred, and is that inspection associated with my DOT number, because even though DataQ doesn't have a deadline for when to challenge the violation, we want to move quickly, because obviously that information, like you just mentioned earlier in the presentation, is getting sent out to third parties. So we want to act quickly to address the violation that's been issued so we can prevent that from happening. Also, the more recent it is, the better off we're going to be in getting that challenge removed from our scores. And then of just, as a best practice measure too, making sure there aren't any other deadlines associated with the violation, such as an agency action, right to appeal monetary citations, or a court proceeding.
Just for your information, there is a webinar that Bridget and I did first of last year that goes through all this. It's posted on our website. If anybody's interested in understanding the DataQ process more, refer you all to look at that webinar, and we spent an hour or so going through exactly the procedures that Bridget just summarized in the last 2.5 minutes for that. Let's talk about the bill of lading. That's the next question. I threw this one into. We look at the active, they're active, but we're also seeing out of service, inactive, authorized for passengers, property, hazmat, not authorized, active. Can you give us a brief overview, Officer Captain Gay, about these kind of nomenclatures we see? If there are any ones there that we need to be aware of where the insured should not be on the highway? Obviously, out of service would be.
Yeah, exactly. Out of service, obviously, they have a FMCSA put them out of service for various reasons: fail to pay the penalty, imminent hazard, and or failing a safety audit. So there's so when they're out of service, it means the entire company is unable to operate, or is not permitted to operate. So inactive is where either voluntarily or for whatever reason, the number there is not out of service, but they inactivate the number. And most time we see this is when someone's registered and has interstate authority, but they don't leave the state. So what FMCSA would do is inactivate the number, and because they're not actually operating interstate commerce, it's valid, it's a good number, it's not out of service, it's just inactivated because they're not meeting the requirements to have a interstate U.S. DOT number or operating authority.
Which one of those? I'm sure. Which one of those could be not updating their 150 information biannually? If that happens, how do you react to that? Is that do you put them out of service? Do you shut them down? The only thing they did is not send the information in. How do you react to that part if it shows inactive?
How do we act when it shows them inactive?
Yes, sir.
Basically, treat them as not having a valid DOT number or operating authority.
Okay. Excuse me. Now you authorize for those items. Then those are where they have permission to hold.
Operating authority is you have to have the general authority to transport passengers or property, and then you have to have additional operating authority for other specific commodities like passenger, household goods, has materials. So when you're authorized to transport those specific types of commodities means you're authorized that you have the operating authority and the correct amount of insurance liability for those specific commodities. For example, pastures, if you transport more than 16 pastures, you have to have $5 million insurance liability compared to general freight, which is only $750,000. So you have to be authorized, mean you could transport those commodities and you have the correct authority to transport it. And then not authorized is basically the opposite, which not being able to transport a commodity that they're not authorized to transport.
But if they're hauling something that does not require authority, like my father hauling cucumbers, that doesn't mean they can't operate. They just can't haul something that they have to have authority for, right?
That's correct. I mean, if you haul something like general freight, for example, like cucumbers, processed cucumbers, then you only need the general operating authority, $750,000 insurance liability. So they can haul that, but they just can't haul anything that requires more authority and or more insurance, like pastures, hazardous material, or household goods.
And active, obviously, they can operate with no problems. You have an out-of-service date, and if they operate beyond that out-of-service date, that's where you have a real problem, correct?
Oh, if the motor carrier, are you asking what will happen if they're operating in an out-of-service, where they're declared out-of-service?
Yes, sir.
Oh, yeah, definitely it's a problem because for us, Florida, if a motor carrier is operating and they're out of service, it's a $10,000 fine on the roadside. And then FMCSA, I believe they charge them also $10,000 for every state they operate in. Okay. So it's a very strict, it's a very stiff penalty, and they will be declared out of service, and the load cannot leave. So it's a lot of problems if they get caught operating when the motor carrier has been declared out of service.
This next slide, if the motor carrier is exempt, hauling again cucumbers, but is hauling something that requires authority, what do you do? And if they don't have that authority, what you just said is that's okay, because if they're all hauling something that's exempt, they can operate even though they don't have authority. Is that correct? I mean, that's what you just went through in the previous slide.
Yes, not all loads are require operating authority. So if they're transporting exempt commodities, and produce is one of those exempt commodities. Not so if they're transporting that requires authority, then if we catch them, then we will cite the motor carrier for operating without authority. We in Florida will issue a $500 penalty to the vehicle that we stop, and we'll place the load out of service, so meaning the load cannot continue unless someone else comes, picks it up, and takes it and delivers it.
But if it's exempt, even though the authority's been revoked or involuntarily revoked it, but if it's exempt commodity, then that's okay, like a cucumber versus a pickle.
Yes, exactly. If it's an exempt commodity, then it doesn't matter what if they had authority and it's inactive, or they just never registered and got operating authority. If it's exempt commodity, then they don't need it, so we don't require them to have the operating authority if it's one of those exempt commodities.
Tommy, if I may, Captain Gay, first of all, welcome to the Tommy Ruke cucumber and pickle scenario. Those of us, Bridgette would be one that know Tommy well. We understand pickles and cucumbers, and that's a good way to look at it. But I want to ask you this question. If you don't have a bill of lading, would it be fair to say that it would be easier for a vehicle that's being inspected to misrepresent who the inspection should be attributed to, because there's no check and balance between what's on the side of the truck and the bill of lading, right?
Well, I mean, that's going to make it a little more complicated, but we don't stop at the bill of lading. we will look at anything, the logbooks, the vehicle registered owner, any supporting documents. Most of the time, I mean, unless it's a farmer moving from a field to the first point of processing, most of the time there's going to be some kind of bill of lading or some documentation, because if I turn over a load of, say, pickles to you to haul to Texas for me, I want some kind of documentation that you received it and you delivered it. So, but if they don't have it, that it will hinder us a little bit, but it won't prevent us from going further and seeing who's actually operating the vehicle at the time.
I get what you're saying, and Tommy, I guess I was looking at it upside down, the situation, and the situation I was looking at was a vehicle misrepresenting to the DOT for the purpose of just getting through an inspection where his insurance resides. And if he's hauling an exempt load and he gets stopped and the vehicle's not owned by the insured, but there's information that shows that he's leased, or he says I'm leased to ABC Trucking, would that inspection maybe easily get to ABC Trucking when in fact the vehicle once again wasn't leased, and you have to rely upon the insured going to DataQ or wherever to try to get that inspection off of his data? Is that scenario a likely one, do you think?
Well, that's what we have on the next slide, is during the inspection, the bill of lading. If the bill of lading reflects...
Well, there is no bill of lading. There is no bill of lading is what I'm saying.
Okay.
This is an exempt load. And I think we hear this a lot about exempt loads. That's why I'm asking.
Well, again, Captain Gay, if I'm a private carrier, I do not necessarily have to have a bill of lading, but if it's for hire, then isn't some kind of shipping receipt required?
No, unfortunately, there's only commodity that requires to have a bill of lading in possession as material.
Okay.
So we could be faced with this whether it's an exempt commodity or not.
All right. The next slide talks about the bill of lading being a different name than motor carriers on the side. Now, what I'm hearing you saying from our previous discussion, even though we have Love Trucking on the side of the truck, if the bill of lading is in the name of Ruke Transportation, the inspection might be reflected on Ruke Transportation, not Love.
Yeah, that's correct. Like I previously stated, we're making every effort to identify the motor carrier, and if we find that the bill of lading motor carrier is different from what the credentials and what's displayed on the vehicle, we will probably ask a little bit more in-depth questions to the driver. Why is there a difference between the bill of lading and the what credentials displayed? And then whatever we get from him or her, we then call the motor carrier who is displayed, the credentials displayed. And if it appears that he's using their authority without their permission, like it was a terminated lease, then we will cite him for not having, or whoever's operating the vehicle, the owner, we will cite that person for not having operating authority and all the penalties and place the load out of service.
Okay.
So when having a different name on the bill of lading compared to what's displayed on the vehicle, that's sort of like a red flag to us.
And they're going to stay there longer. John, you mentioned the proof of insurance. What do you require for proof of insurance, Captain Gay, and what do we need to provide as an insurance provider to meet that requirement?
Well, on the roadside, the only thing we will ask for is proof of insurance for that vehicle being operated, and that's state law. Now, as far as any kind of MCS 82, MCS 90, or anything like that they need to show proof of insurance to FMCSA, and when they file their insurance certificates to FMCSA, they're not required to have that on roadside.
So all you require is the ID, the insurance ID card to that vehicle in that cab, which is what we give out all the time.
Yes, and that's state law that requires them to have that in possession. We do go to FMCSA's website, License and Insurance, LMI website, SAFER website, and we will verify that the motor carrier has the correct amount of insurance, and through that way. What the motor carriers and what you guys can do is ensure all the proper filings are filed in a timely manner with FMCSA, so it's active and everything's good on file with them, because that's our biggest way of verifying it. Now we can verify if that specific vehicle has a insurance identification for that specific insurance or for that vehicle, but it doesn't give you all the information like a MCS 82 or MCS 90 form.
Now, in this question, what happens if, again, the insurance is in Ruke Transportation, yet my DOT number on the side, and I'm leased to Love Transportation? Do you match both of those up, or you just look at the vehicle, the insurance verification on the vehicle that I'm operating?
Well, we try to verify and make sure that, because there are carriers, and I don't know if Bridgette can expand on this. There are carriers who will lease a vehicle onto piece of equipment, lease a vehicle, but the owner of the vehicle brings his or her own insurance.
Right. That's something that we've seen more often. Yes, sir.
Well, there may be discrepancy between the insurance for the vehicle and the motor carrier. So it's one of those things, we see any discrepancy between two different items, we will try to investigate further and call the motor carrier to make sure that they are responsible for the load.
How often do you see those conflicting, those conflicts you just described? How often do you see something like that, would you say?
My experience on the road is like I was mentioning in the beginning of this webinar, it's usually the new entrant, the companies that haven't really established. The reputable companies, most time they have everything in order, the insurance, proof of insurance, lease agreements, credentials. Now you get those rogue owners who will terminate their lease but continue to use their authority. But for the most part, as far as having conflicting documents, is usually these new entrant small companies that are just establishing themselves.
Bridgette and John, do you all have any more questions or thoughts?
Yeah, I just have one situation to share that has come up before, and this is sometimes associated with, let's say, suppliers that either don't realize they have to get motor carrier authority, or maybe they just applied for operating authority and they have one or two trucks on the road. They'll get pulled over and they'll get a violation. We'll issue a vehicle examination report, and let's say it'll be a violation under 390.21b, which the carrier name or the USD number required not displayed. So, Captain Gay, when that happens and you have a company that doesn't have a DOT number, but they're hauling, and the vehicle that they're hauling qualifies as commercial motor vehicle, where does that information ultimately go to? Because there is no assigned DOT record or file.
I'm sorry. If the vehicle's operating and it does not have a DOT number?
Right. What is do you know what the FMCIEF or on the state side, what they do to enforce that?
Well, we will as a motor carrier, we will, if it's a company, we'll put the company name and address. If it's an individual, we'll put his or her name and address. So whatever that name, it will go into SAFER under that name, and then later, if they ever get a DOT number, all that stuff will match together.
Now, the next question is, if they don't have a DOT number, do you do anything, and they should have a DOT number?
Yes, we will cite them for not having a DOT number, and on the driver inspection or driver vehicle inspection, We will cite them for not having a DOT number under whatever name they're using at the time, and then also we'll cite them a civil penalty on the roadside.
And would you put them out of service, or would you let them go ahead and complete their haul when that doesn't match?
Well, no. For not having a DOT number when required is not a out-of-service violation.
Okay.
An out-of-service violation. The only thing we could place out of service is the load when they're required operating authority. Right now, currently, we will allow them to continue. We will cite them the violation and the civil penalty, but we will not place them out of service for not having a valid DOT number. Now, if they're required operating authority, then we will place the load out of service.
John, Bridgette, anything else? Captain Gay, you go ahead, John. I'm sorry.
No, it's very, very informative. I mean, we're not going to be asking less questions in the future about VINs and inspections, and I think as the insurance industry looks closer at VINs, Tommy, that we need to learn more about what it is that Captain Gay and everyone is doing in their inspections so that we understand the plausibility of a VIN being inspected where we're not collecting premium. It's inspected under our DOT number, but we're not collecting premium. That scares every insurance company, and, you know, without any further explanation, and it's got to be a pretty detailed explanation, I think it should scare every insurance company. Don't you agree, Tommy?
Absolutely. This is why, you know, you and I talk about putting this program together. And Captain Gay and Bridgette, y'all gave us great information concerning this. It's going to be an ever going on process, and I'm sure we'll come back and ask you and Bridgette or your comrades up there, Captain Gay, to help us understand this more. The more we understand your activities on the road, the better we are able to interpret it and provide the proper insurance for the motor carriers. And I think that's both of our view, is to make sure the motor carrier is operating properly and has the right insurance, and that we kind of marry these things together. And we appreciate you doing this. So our foundation, we thank you, Bridgette. We thank you, Chief Thompson, for putting this program together, and Captain Gay for being a part of it. Okay, it helps us all in this area.
Our pleasure. Thank you, Tommy, for having us.
Captain Gay, we appreciate your time today. We hope you have a good day and a good 2017. John, as always, appreciate your input. So this ends this webinar. We'll look forward to seeing you on the second Thursday of February.